We are live, sir.
Greetings to everyone present. My name is Ankit Malhotra. I'm the co-founder and president of the Jindal Society of International Law. The society is a student-led initiative under the Aegis for the Center for the Study of United Nations, which is formed under the expert guidance and tutelage of Professor Dr. Weston Mccaskey. This society was launched on the 18th day of November in 2020 by the Harvard and Rose Rubin Professor of International Law, Professor Jose Enrique Alvarez, along with our university's respected Vice Chancellor, Professor Dr. C. Rajkumar, and a very dear friend of the Center and Society, Professor Dr. Mohan Kumar. The purpose of the society is to increase the student engagement and interaction with the subject matter of international law through all its various initiatives. Rather than being primarily research driven, we intend to offer a host of experiences that contribute towards skill building, thereby increasing the knowledge database which is available to our student members. The society is also an attempt to bridge the lacuna by streamlining the resources of international law and its vast expanses. We aim to provide a space to young international law enthusiasts to nurture their interest in this field of law. Therefore, as the spring lecture series entitled Colloquium on Challenges to Global Governance and Humanities in the 21st Century, it offers a compendium of scholarship from the academy and professional experience from the bar. Over the past year, the Society has hosted over 100 renowned speakers from foreign universities, members of the International Law Commission, international law firms, the United Nations, the Institut de Droit International, the World Bank, and also the Hague Academy of International Law. May I also here at the Max Planck Institute of International and Comparative Law. Through our previous series, we endeavored to study the different contours of international law through the speakers who cover and address their respective areas of expertise based upon their years of research and practice. Given this vast ecosystem and the engagement of international law in it, the society attempted and aimed to study the fragmentation and fertilization of these various disciplines in the ecosystem of public and private international law. Over the years, the society has become a quorum of thought-provoking discussions due to the engagement with experts at exploring this ecosystem of international law. Thus, as a result, through the spring lecture series, it is important to understand the law and its challenges from broader, different, and differing vantage points. Acknowledging that international law is a creation of states, it is also important to understand and appreciate the social sciences and humanities that have played a key role in shaping this law. Thus, a broader study becomes not only critical but also crucial. Through the series, it is also hoped that one will develop a deeper understanding of Philip Jessup's magnum opus, A Modern Law of Nations and Introduction, which he wrote in 1949, and he said, and I quote, "So long as the international community is composed of states, it is only through an exercise of their will, as expressed through treaty or agreement, or as laid down by an international authority, deriving its power from states, that a rule becomes binding." End quote. Today, we challenge our speakers to reimagine international investment law, but to invite a student member of the society and also dear friend, I have Mark Sass who will also moderate the session. Lara. Lara is an international arbitration practitioner who is qualified in New York. She holds an LLM in comparative and international dispute resolution from Queen Mary University of London and worked in commercial and investment arbitration at international law firms. Lara has also worked at the ICC, which is the International Court of Arbitration, and represented an observer delegation at the UNCITRAL Working Group on Arbitration and Human Rights Council. Lara has clerked for Justice of the Supreme Court of Israel. Most recently, she advised states on matters of public international law and treaty negotiations at the United Nations, and is now currently working with Russia, against Russia for Ukraine on matters of international law and importance, which are dear and near to all of us. Lara, I now invite you to moderate this session. Thank you.
Thank you, Ankit, and a warm welcome to everyone. So you will have seen the bios of our speakers on the poster promoting this event. Nonetheless, I want to highlight some points. I'll start with our first speaker, who is Dr. Martins Peparinskis. Martins joined the University College London Faculty of Law in 2013. Prior to that, he was a fellow at Oxford University and a research scholar at NYU. Martins holds an LLB from the University of Latvia, an MPhil and a DPhil from the University of Oxford. His research expertise is reflected in his appointments, and to name one of his notable appointments, it was in 2021 when he was elected a member designate of the United Nations International Law Commission by the General Assembly. Our second speaker today will be Gunjan Sharma. Gunjan is a New York qualified attorney and a partner at the public international law firm Volterra Fietta in London. As part of his contentious practice, he advises clients on complicated issues of public international law and counsels them on how to protect their overseas investments. His non-contentious experience includes providing investment and dispute resolution advice in over 300 large commercial deals and many more areas. Finally, our third speaker will be Shreyas Jayasimha. Shreyas holds degrees from the National Law School of India and University of Warwick, which he attended as a Chevening Scholar. He is the founding partner of Arna Law and has 20 years experience in litigation and international dispute resolution. He is a trained mediator and also acts as an arbitrator, and he is currently acting as co-counsel for a state party in 2 ongoing investment treaty arbitrations. So all our speakers have impressive bios, as you can see. You will want to read them in more detail, and I very much encourage you to do so. Ankit has already given us an excellent introduction to today's topic. And so without further ado, we will get started with the main part of today's webinar. Please remember that you can ask questions. We really encourage you to do so, and you can do so via the Zoom chat function or the Q&A function. I will now hand the floor over to Martins, who will talk to us about the broader public international law setting within which investment law's reimagination takes place. Martins.
Well, thank you, Laura, for the very kind words of introduction, and thank you, Ankit, for having me back. And may I again congratulate you for the splendid work that you have been doing with the Society and the lecture series. As Laura said, I propose to put our discussion within the broader public international setting, which I think is quite fitting as well for the series and well as for this talk. And I will talk for about 10 minutes, and I will make 3 points. The first point, and I think perhaps I'm not the only one who thought of that when seeing the title of the talk, was to recall a favorite expression of the late and much missed Judge Crawford, a giant in public international law and international investment law, who would often say when seeing talks or events entitled reimagining, rethinking, or reconceptualizing, in a somewhat dry way, express some doubt whether any thinking or imagining had been taking place in the first instance. So I think it is helpful, as it were, to win the clock back. What is it that is being balanced? And here I think my thesis, I would imagine not terribly controversial in a lecture series dedicated to public international law, is that international investment law, as we now know it, warts and all, was set in its fundamentals in the public international legal order of 1960s to 1980s. In a very particular setting, it was not something that was, as it were, written on a blank sheet. It was something that took place at a very particular moment of the international legal process, decolonization, clashes between various approaches to international economic regulation at the General Assembly, and as a countervailing factor, a particular approach to setting of the primary obligations in investment treaties, as well as dispute settlement mechanisms, originally classic interstate dispute settlement mechanisms, but then building on that basis, the important innovation of investor-state arbitration. Now, we all know these basic steps, but I think it's helpful to remind us of the baggage and vocabulary that brings with it, the assumptions of certain actors, sources, responsibility, dispute settlement, within which the balance between various interests, and in particular those of host states and investors, is struck. And there have been different ways, of course, to retweak this balance, but in its fundamentals, the way of thinking about these matters is still there. Now, how is it helpful to put the Reimagination project in that broader setting? And I think that it is helpful both when thinking about these matters, as it were, at the macro level, reflecting on what is explicitly described as reform proposals in various settings, be that Ancestral Working Group 3 or the recently concluded ICSID rules amendment project or modernization of Energy Charter Treaty, to name but three, but I'm sure that all of you might think of other examples, as well as at the micro level, because the interesting disconnect in imagination of investment law is the heated contestation simultaneously on its foundational issues that suggest a variety of ways of completely transforming investment law as we know it, and on the other hand, fairly uncontroversial application of the very classic model of investment law, the same 1960s and 1980s model that would be broadly still familiar to Aaron Brockes and Rudolf Dolzer. So how is it helpful to put investment law in the broader macro setting? Well, it seems to me that it is important by appreciating the variety of approaches how public international law can strike balance between competing interests, both within this field as well as in other fields. And I sometimes wonder when listening to debates whether the scope of creative imagination is somewhat set by the contiguity of sources of inspiration in that regard, whether investment law is necessarily conceptualized around the axis of a dispute settlement. Now, that is not necessarily the case, as I will say in a moment, in public international law more generally, nor arguably was it the case for the founders. So I was a co-author of a recent piece in the Journal of International Economic Law, where we looked at the archival materials of the first treaty drafters on BITs from UK and Germany, and the dispute settlement mechanisms were more thought rather than as the driving focal points, but at most the backdrop against which the interstate discussion took place. So the point I think I want to make here is that dispute settlement is not the only frame around which we can think, as it seems to me that even in the ancestral process, where very interesting questions are posed, it is still the contiguity of international economic law more generally. It is the World Trade Organization and the assumptions of a certain institutional system that drive the debate. And that is not necessarily the sense in other settings. If we think of other very important fields of international law, think environmental law, think climate change law, think BB&J in law of the sea setting, I think we are immediately appreciative of the proposition that strong courts or inevitability of full reparation is not an indispensable aspect of making a public international law. Now, that does not mean that they shouldn't be there. Perhaps investment law is a precise setting where this instrument and this mechanism is important, but I think sort of perhaps in the sort of idea of the thousand flowers blooming, that those who are trying to imagine investment law should throw their gaze beyond the contiguous fields of practice in commercial arbitration, litigation, and dispute settlement mechanisms. Public international law is much richer in its diversity. So that is, I suppose, imagination as far as the future goes. The third point that I want to make is that perhaps imagining or reminding ourselves of the public international law foundations of international investment law helps us greatly with thinking through the hard and thorny questions in everyday interpretation, application, and dispute settlement, recall the puzzle. Everything is changing, but ultimately in day-to-day practice, relatively little is changing. So we also have to think about how to creatively apply things on the ground. And I think that here, it is always, I find, helpful not to forget, perhaps not to remind rather than reimagine, of the basic foundational propositions of international law, as important in investment law as elsewhere, set in a number of important decisions, that there are distinctions between primary rules and secondary rules that we know from Vivendi 1 annulment, that there is a difference between obligations imposed by international law and not, as MTD annulment award taught us, that there is a difference between primary rules and their exceptions and circumstance precluding wrongfulness, as CMS reminded us, that an interpreter needs to diligently and explicitly carry out their exercise and mandate, as Sir Frank Berman noted in his opinion in Lucetti, that there is a fundamental difference between international law and domestic law and treaty law and customary law, as Sir Frank Berman chaired a committee again noted in ExxonMobil. Seemingly very straightforward propositions, but if you remember those cases, you'll also remember the brilliance of the arbitrators at the tribunal level, who occasionally had nodded on precisely these points. So it's important to appreciate them as a general proposition and also implement in the bread and butter work of legal reasoning. So I think that there are 2 points in particular where it seems to me that reminding ourselves of basics would help us very much with certain thorny issues. I think that reminding ourselves of the distinction between basics on interpretation application, as well as the difference between vagueness in the sense of opposition to concreteness and in the sense of obscurity, would help us very much think through the hard, fair and equitable treatment questions. I also think that reminding us of the remedies proposition, that as a general matter, reparation does not follow conduct in compliance with primary obligations unless primary obligations themselves impose that obligation, a point that the famous ECHO, Oro, and Columbia Award may not have fully appreciated, as well as other very, very important questions. So I think that that sort of brings me back to my original point. To reimagine, we have to have a clear sense of what it is, as it were, object and issue that we are trying to recalibrate. To know that, we have to speak the language of the discipline and to appreciate the balance that is being struck. And I think that once we are there, we know what we have a sense of how things generally are done in international law, then the effort of imagination can really start. Thank you, Lara.
Lara, you'll have to unmute.
I always do this. Thank you. So this was really interesting, looking at investment arbitration, not just on a blank sheet, looking at the context, and a reminder to not just reimagine, but to remember. This is just a reminder that if you have questions, please put them in the chat or the Q&A function. We will now turn to Gunjan, who will talk to us about contract strategies to adapt to a changing ISDS paradigm. Gunjan, we look forward to hearing more about this topic. The floor is yours.
Thank you so much, Laura. Thank you, Dr. Paparinskis, for fascinating discussion. To be honest, I could put aside these slides and spend the rest of the hour saying where I agree with you and where I completely disagree with you. And I think, but that's absolutely fine. I will stick to my subject matter, but I'll pepper in. But and I hope the slides are visible. I wanted to talk today about the practical implications of what Dr. Paparinskis is talking about, which is the so-called reimagination of the investor-state arbitration framework. And Dr. Paparinskis said something which I think hits the nail directly on the head, which is that although there's a lot of reimagination of ISDS, and in my view, that reimagination is really a secretive way to try to kill it. The on the ground practice of protecting large-scale investments through the dispute resolution mechanisms are not changing on a day-to-day basis. And on a numerical basis, I did a survey recently of 100, we found 212 bilateral investment treaties signed in 5 languages over the last 10 years, and we were able to review 189 of them because we knew the languages. If you look at the numbers, only a very small percentage of those new treaties, of those investment protection treaties, actually fundamentally change the practice of investor-state arbitration. That said, if you are an investor today, you should be aware of the risk that certain political entities, certain NGOs, certain governments are engaged in a process of trying to undermine investment protection through the auspices of public international law in the form of investment arbitration. And because investments have 10, 15, or 20-year timelines, you need to start thinking about how can I protect myself from adverse changes that may occur. So, going quickly through my slides, here you go. Because I'm speaking to an Indian organization of international law, here's a good example of adverse impacts that occur from changing the paradigm of investor-state arbitration. India has terminated its 69 bilateral investment treaties since 2017. Really as a consequence of the actions of people like myself and others, not actions, but the representation of clients who have brought large-scale disputes against India and roundly won them before investor-state arbitration tribunal. So the reaction of the Indian government was to cancel the treaties. Yet it did so in the framework and in time when increasingly Indian companies have large cash reserves that they're investing overseas. So at the time the Indian government terminated its treaties is precisely when Indian companies are diversifying their foreign investments and increasing foreign investment flows. So India effectively reduced the protections to its own investors to protect its government from large-scale claims. Right? So that's a consequence of the reimagining of investor-state arbitration, such as through the draft Indian model bid. Very basic concept. This is the core issue which investment arbitration deals with, which is that for many types of large-scale investment projects, which make fundamental differences in the economic performance of a country, the negotiating leverage between investor and government shifts considerably and quickly. At the initial transactional stage, the investor with its balance sheet, presuming you're contracting with a state-owned entity or the state in some way, the investor with its balance sheet has some greater leverage. Not over the government, but it has leverage because it has money. And it chooses where the money goes. It can choose, am I going to invest $1 billion in India? Am I going to invest it in China? Am I going to invest it in home? It makes that election. And that leverage gives it leverage to require certain components from state and state-owned entities to review the legal systems in certain ways that are preferential to it. After you've invested in a country, you've built the infrastructure, you've expended the capital, you're now waiting for the profits to come in to recoup your costs and then make a profit. So you're waiting for cash flow to recoup your costs. Now the government has a leverage because it has the government power over your assets. And so inevitably, I mean, if I'm sure someone did this survey, inevitably investment disputes never really often arise when well-funded investors are making their investments or considering making their investments. It's always after the road is built, right? 90% of the time, 80% of the time. That's not always true. But in a lot of cases, it's after the concrete is laid, after the transmission line is built, after the power plant goes online, then you get the dispute. Because the negotiating leverage which the investor had at the beginning is shifted towards the government. What does that mean if you're an investor, and if you're one of my clients or one of the clients of many of my peer firms, is it's early in the transactional phase, in the pre-investment phase, that you should be seeking to maximize legal protection. And this is basically, I hate animation, but I forgot that I was animated. Okay, this is basically what the board decision when you're making an investment is, right? The general counsel won't know all the particulars of international investment law. They might know some. For sure, the CEO is going to know very little about this unless they're in very specific industries like oil and gas or mining or etc. All they want to know is an answer to this. What's my legal risk in this investment? Is it high, medium, low? And they take that into account, and then they look at the profitability and they look at the economic determinants and they say yes or no to the investment decision, right? And when they're making that assessment, they need to be considering, and this is where Professor Pavrinskis was absolutely correct, they need to be considering the contiguity of international economic law. That is the source of protections for investors that emerge from really three fundamental sources. Your contractual rights and guarantees, including unilateral guarantees, specific to the investment. The domestic law of the host state, which includes not only its formal laws and statutes, but also its practice of law, what we in the public international sphere call the rule of law. And then finally, investment treaties. And this is the most ignored one by investors. These special investment protection treaties that supplement the basic legal protections arising from contract and domestic, right? And if you're not looking at all three, you're failing the holistic analysis of what I was talking about before, which is the legal risk analysis for the investment decision. If you're making a 15 to 20-year time horizon investment, however, it's not enough to look at the current state of the law. Just very quickly, I have a slide here. Everyone knows this on this one. Bilateral investment treaties all over the world. There's over 2,500 of them. They're all types, all different types, but they provide basic protection. Okay. If you're making a 20-year time horizon investment, and your analysis or the analysis of your legal counsel is talking about the law as it is, that doesn't work. Because very quickly, within a generation, or 20 years is 2 generations. Very quickly, within one political election, within the next one, there can be wild swings in government policy and approach to investment. You see that in India, you see that in Latin America, you see that nowadays in the United States, you see it in England, you see everywhere. The political dynamics are determining government approaches to investments, and there's a swing. So you need to take a 20-year time horizon, and when you're taking that 20-year time horizon, you have to think about these things like the termination of India's BITs, the termination of intra-EU BITs, the weird investment protection in the USMCA. I was involved in the USMCA discussions. I talked to the ambassadors as the trade representative. I promise you that was not a policy-driven investment protection clause. It's a mess because the politics were a mess, not the legal analysis, not the consistency, right? All of these things are a backlash against investment protection, which, as I said, are not really taking hold across the board. That's a dirty little secret that Untittled Working Group doesn't want you to think about, that all the opponents of investor arbitration don't want you to think about. States are still signing investment protection treaties at a clip without fundamentally changing it. But they will soon be, and then in core jurisdictions, it is happening. For instance, the Dutch are pushing a new Netherlands bit, and a lot of people have protected themselves with the old Dutch bit. You need to think about that. And so what I advise my clients to do is to think about that at the transactional phase when they have the optimal leverage, right? They're making the choice to put $1 billion, $2 billion, $4 billion in one country or another, right? I've advised clients who, on an equity basis, no incurrence of debt, said I'm building a downstream chemical manufacturing plant and I'm choosing to do it in an East Asian country, a South Asian country, or a Middle Eastern country. Can you give me the legal risk analysis of each of those, right? So at that initial stage where you have the leverage, that decision-making power, push for absolutely legitimately, there's nothing incorrect or improper in this, push for contractual guarantees with states and state-owned entities that deal with the potential reform of investor-state arbitration. Here are some basic clauses that I push for. Arbitration in neutral locations, neutral governing law clauses. That's basic practice. don't link material breaches of contractual performance to these kind of common law concepts of material breach. Give specific indicators for contractual performance, including reference to precise standards, even if it's as simple as the international standards of the oil and gas industry. That's more precise than material breach. Push for stabilization clauses, which are clauses that guarantee that the legal framework at issue in the country will remain, at least as applied to your contract. And because stabilization clauses are under attack today, the Supreme Court of Israel declared them unconstitutional in Israel. Push for something called an economic rebalancing clause, which mimics the administrative law concept in civil law, through which the judge or the arbitrator can rebalance the economics of a contract to guarantee the investor the same levels of profit it expected despite changes in regulation. Another thing I do, and I've done successfully, a lot of people think there's no way this is going to get through the regulator. There's no way going to government. Governments will agree to this. Duplicate your investment protections, such as compensation for expropriation, fair and equitable treatment, etc., as contractual commitments. I did that offshore Eastern Europe for an oil and gas commitment. The government agreed to basically a cut and paste of the expropriation, FET, and MFN clauses into the oil and gas contract, PSC. And I did that in a roundabout way in Rondo 1 in Mexico, where the Mexican government did not agree to a cut and paste of the protections, but agreed to sustain the protections found in treaties for the investment. And that's the Rondo 1. You can just download it and look online. You'll see it's very good. Further measures, and I should mention I gave a presentation similar to this to Shreyas's team at Arna Law, so he has a little bit of a duplicated. Further measures, if you can't get a bilateral contractual degree, get a unilateral guarantee from the state. It's always better to get a bilateral contract because you can't amend a bilateral contract unilaterally, but at least the state has a unilateral guarantee that gives you certain protections that you can then bring up in an arbitration later. I got one, me and a client got one from a South American company, or from a South American country in regards to a large offshore operation. And plan for disputes even when they don't arise. Take your on-the-ground measures to protect your foreign investments. Make sure data is available externally. Sometimes make sure data isn't available in the host state. Interesting little facet of the Crystalex dispute. In Crystalex, a significant portion of the settlement, over $1 billion, I think, was dedicated to the return of the geological information that the company had taken from Venezuela but not left a copy of. So effectively, the Crystalex mine was valueless, well, not valueless, but was very difficult to operate without the geological information the company had kept in Canada. And so a great driver, it appears from the outside, I wasn't involved in the settlement discussions, right? A great driver of that settlement appears to be the retention of information outside the country. And the same thing with factory manuals, factory training forms, etc. It just helps. And nothing illegal, nothing improper. Always satisfy your health and safety standards and your regulatory standards. But as long as you're doing so, protect yourself. With that, I wanted to make sure I hit 10 minutes, and I hope I did, Laura. And I welcome Professor. I will say one thing. Professor Paperinskis talked about the reimagining of investor-state arbitration outside the dispute resolution context. And that, I think, is the key concern for investors. It's this idea that you're going to get a paper treaty that gives you a bunch of rights, but then you don't know where you're going to enforce those rights. And the teeth of an investment treaty is the protection of international arbitration. It really just is. So if you're worried, and there are practitioners who are more worried than I, but I'm still worried that arbitration of investment disputes is going to be pushed away, this is how you have to practically protect yourself at the earliest stage. Thank you, Laura, and thank you, everyone.
Thank you, Gunjan. That was really interesting. I already have a question noted down, but we'll get to that later on. So our final speaker for today is Shreyas, who will talk to us about investor-state mediation, drawing on the IBA Mediation Committee's work, ICSID, and the recent suggestions at Untitled. I will hand over to Shreyas now.
The organizers, Ankit in particular, and thank you, Lara, for moderating this, and greetings to my fellow panelists. It's been fascinating to listen to you all, and I apologize in advance for some background noise that you might hear. I've tried to set the computer settings to block out all unwanted noise, but if you do hear it, pardon me. I speak to you as a practitioner, much like Gunjan. And this is the song which is perhaps now fashionable, but I must state that I got trained as a mediator in 2008. It wasn't a fancy thing to do. And mediation was often confused with meditation, adding a few syntaxes here and there. But I don't think that Freudian slip is entirely inaccurate. The seeking of inner peace through meditation, or the ability to catalyze a more lasting peace between parties beyond a dispute resolution mechanism, which is adversarial, either in the form of arbitration or in the form of even state-to-state litigation, if that is to arise, is something to contemplate on. It's all very well to point at legal nuclear weapons, such as investment treaty claims and extreme actions that people can take if all reasonable conduct and conversation were to break down. But surely that is not the only option available in the menu of options to all parties. And there has to be at the top of mind of all actors, after all, who is the government? The government could be bureaucrats, it could be politicians, diplomats, but persons who must constantly be reminded that it is only lawyers who are in the business of disputes. Everyone else in the room is in the business of either attracting or maintaining significant investments, which is long-term, large capital, and maintaining peace in this whole investment cycle is critical. And so, as interesting as to us lawyers and academics, the legal aspects of a, let's say, an investment treaty dispute that could arise, ultimately, in the absence of even any form of stare decisis, precedent, or even sometimes even publication of some of these awards, it is not merely an effort to fill a gap in the cusp of private public international. Rather, as a practitioner, I would posit that the top of mind concern for all actors at all stages, and this is often a simple fact which is lost to many, which is to consider either negotiation, mediation only at the outset. If there's one point that I wish to get across, it is this, that the instinct to seek a negotiated or mediated outcome cannot be limited to the stage prior to dispute. Of course, your investment treaty clauses matter. Of course, the clauses of the contract that Gunjan just spoke about matter. But what I'm pointing to is a matter of best practice. And I think over time, those actors, lawyers, arbitrators, and others who are able to display a certain acknowledgement of the ability for the parties to retain their agency, even perhaps parallel to an ongoing arbitration. A mediation offers an opportunity for, let us say, a reduction in the scope of dispute. Not everything is an entire victory or an entire loss. If there are, let us say, about 15 issues or 25 issues in dispute, the limited mediation may restrict the true scope of the dispute with the parties to 5 or 7. It could even be on procedural issues. For example, if there is some agreement to be arrived at between the parties on the ground rules for the appointment of experts as well. And I would even suggest that the time has come for us to contemplate, especially at least in contract, for us to acknowledge that this is not a phased or tiered way of approaching disputes. It is not a mere dilatory tactic. It is not a fishing expedition, as cynics often point to mediation to say it is a fishing exercise to try to discover the evidence of the opposite. But when used responsibly, both in terms of procedure and in terms of substantive disputes, mediation can narrow the scope of disputes. And mediation, when used effectively, can even resolve certain anxieties which have magnified disputes between the parties. Anticipating this, and it is to Gunjan's point, not just states who are seeking some sort of a change in the approach. I would say investors as well are keen to ensure that they're not in this perpetual state of conflict with certain high-risk states as well. And so there is an overarching need, an economic need, a social need to maintain some sort of civilized discourse, even in the midst of acrimony and legal disputation. And so practitioners who are purely private practitioners, such as those in the IBA, produced an instrument which is nearly 10 years old now, on investor-state mediation rules. And it was perhaps slightly ahead of its time in that it was not anticipating the level of the debate that the UNCITRAL committee is now witnessing in working group number 3. But even much earlier to that, had identified some of the essential elements of what could be perhaps successful mediation. One of the obvious constraints to applying mediation in an investor-state context as opposed to a commercial dispute is the issue of sovereignty and sovereign actions. And sometimes the action that is of a state that triggers an investment dispute could be an act of parliament. It could be a decision or a lack of a decision by judiciary. It could be decisions taken by other state actors, which it is very difficult for a diplomat or a bureaucrat or an individual person to have the constitutional authority to mediate or to reconcile or even take one step away apart from a full defense of the matter at issue. But again, this is where creativity is required. And simple and empowering option that mediation introduces is a vacuum, of limiting the consequences to suggestions that are made by either parties. If the same suggestion is made in the midst of an arbitration or a correspondence, issues of estoppel or other aspects of consequences would arise. But the mediation, when conducted either with joint caucuses or separate caucuses, would enable parties to ventilate positions which could be explored much more creatively than in either direct negotiation or in an exchange of formal pleadings. Moving very quickly within the exit system as well, the mediation procedure is acknowledged. The figures are extremely high, that it is approximately 35% of initiated arbitrations are either seem to be ending in settlement or are entirely discontinued. And this implies a very significant role that mediation procedures could have. Now, there is some hesitation as well on the question of enforceability of purely mediated settlements, and that is it just a mere contract between parties once more? Is it higher than that? And which is why you have suggestions such as the Med-Arb procedure, which formally convert an agreement that has been arrived within the parties to perhaps a consent award. which then endures the benefits available under the new convention and other conventions straight away. Keeping in mind the difficulties around investment mediation, it is pertinent to note that the Singapore Convention avoided inclusion formally of mediation of investment treaty disputes within the conceptualization of the Singapore Convention. It has perhaps retained the debate to occur more thoroughly. There have been very few publicly reported successful mediations of investment treaty disputes, but there are some reports of mediations occurring under, for example, the ITT rule, and also noted examples of mediation that have been attempted, and for one for 5 hours in one case, and another case for 1,047 days, which are also available. Coming finally to the work of UNCITRAL Working Group number 3. Of course, it is states that asked for this working group to be set up. I remember being in Vienna at the 50th anniversary of UNCITRAL, and that the table thumping that I was very surprised to see when the idea of working group number 3's wanting to be constituted was mooted and was encouraged and cheered for so enthusiastically. And of course, you could also very quickly see those states in the room that were refraining from thumping the table, those who were even red in the face as the suggestions were being made. But as the work of UNCITRAL Working Group number 3 has continued, it's very interesting to see the academic forum inviting suggestions of the worldwide academic community and the separate from the delegates to the UNCITRAL deliberations. I myself have been attending quite a few of the deliberations as representative of Law Asia, which is a lawyers' organization in the Asia Pacific region. I would commend the attention of the audience in time to look at the position paper issued by the Secretariat of UNCITRAL on mediation and other forms of ADR. In this paper, they have outlined the background information, the reference to possibility of mediation under existing investment treaties, the options available in the absence of a formal reference to mediation so far, perhaps by way of an undertaking given by the parties to conduct mediation, and also suggestions such as, let us say, the approach of the Mauritius Convention, when it tried to retrofit concepts of transparency into existing and ongoing investment treaty disputes. And so if there can be an opt-in provision, for example, to deal with mediation as well. And these are some of the opportunities, options that are being considered. Some of the more controversial options are considering mandatory mediation, and the word mandatory always alarms persons dealing with consensual dispute resolution processes. But it is certainly one of the options that have been so considered thus far. Let me conclude by again reminding us that many stakeholders that are involved, not just the investor and the state, but if, for example, it's a procedure where, as Gunjan referenced, non-state, like for example, NGOs, other individuals who seek audience before the adjudicating body in terms of a complex dispute. In this milieu, mediation also has a role. It is not my suggestion that mediation is here to replace or supplant arbitration. It is just that mediation, when supplemented with the existing sets of negotiation and arbitration provisions that may otherwise be there in contracts, I would posit, produce far more creative, perhaps even far more lasting solutions, which even purely adversarial arbitration resulting in an award in favor of one party or another could never achieve. Thank you very much for your attention.
Thank you, Shreyas. That was certainly very interesting, I think, especially for those of us who are arbitration practitioners and don't know much about mediation. So I'd like to open the floor to discussions now. I have a few questions of my own here, and I see that we've also gotten a question from the audience to everybody. I'll start with a question to Shreyas and Gunjan, and then afterwards I'll follow up with a question to Martins. My question to Martins is a bit longer, so I don't want to confuse the audience too much or myself. Gunjan, you spoke of the fact that you said that investors should really push for having their rights be heard. And my question is, how can investors assess what bargaining power they have in the negotiation of the contracts, and how realistic is it for them to be able to implement these strategies you spoke of? And my question to Shreyas is, so the newest generation of investment agreements often have explicit express references to mediation, as I saw, but they seem to be voluntary. And I only found the Hong Kong UAE BIT and the Indonesia-Australia Comprehensive Economic Partnership Agreement that provide for mandatory conciliation, albeit not mediation, as a precondition to arbitration. So I was wondering, do you think that there are benefits to making mediation a mandatory first step in dispute resolution under investment treaties? Is it even realistic? Perhaps you'd like to start, Shreyas?
The infamous head nod came in the way. It was sorry, Gunjan. I ended up having to again. Well, I personally speaking do not agree that a mandatory mediation procedure would be helpful. This, in my view, should emerge as a demonstration and not an exhortation. Not merely asking people to try it, see if you like it, otherwise pick another flavor in the ice cream shop. That's not what this is about. Again, the presumption that mediation is only an option at the beginning of the process is incorrect. And this suggestion that to make it mandatory and at one phase alone, in my view, only reiterates that misconception. Instead, if there is a growing compendium of instances where mediation could occur at the beginning, as I already mentioned, at the stage, at procedural stages, and perhaps at a stage where prior to the setting of the hearing dates itself, if the arbitrators were to make it best practice to seek again a confirmation from the parties as to whether they still wish to stick to those hearing dates, or just remind the parties that they are always at liberty to seek a resolution of their dispute consensually through negotiation or by other means, including mediation. Some of these gentle nudges, which do not impede in either the fairness or the neutrality or the perception thereof by the arbitrators, would go a long way, rather than a mandatory mediation procedure, in my view.
Thank you. Gunjan?
Laura, I'll answer your question. If you don't mind, I just want to make a comment to the question you posed to Shreyas and Shreyas's point, if you don't mind.
Of course.
99% of the bilateral investment treaties in the world contain a mandatory mediation procedure. It's called a cooling off period. You have to send the notice of dispute, and then implicitly the state is required to engage in discussions with the investor. What's remarkable about cooling off periods is that they're more often invoked merely to delay the time until the investor files a claim, without states actually engaging in the process of the discussion. Right? I had a case. I'm doing a case right now, multi-billion-dollar mining case. Right? We sent a notice of dispute without an answer for months. As the 6-month cooling off period comes to an end, we resend it to the highest levels of government, the pages of the recipient. They don't respond until the last possible moment. And then they said, we'd like a discussion. And then what we find out is from the moment they got the notice of dispute onward, and this is in the public record now, and they admitted it in Parliament, they were trying to pass a statute that would deprive our clients of compensation owed to them as a matter of both as a matter of both domestic law and international law. And I'm not talking about a third world country, I'm talking about a Western country. This is a Western economy, developed democracy undertaking this kind of actions. Mediation works provided the state is interested and the investor is interested. The vast majority of investment disputes in East Asia, in China, in Vietnam, will never get onto GAR or investor IAR reporter, because when they are raised, they are dealt with through mediation. Not formal mediation, but if you have a problem in China, the government will sit down and they'll talk it through, and more likely than not, it will be settled. And that's why there's so few cases against China or against Vietnam. It's not that there are less disputes, it's that there's more settlement, right? So mediation works, but you have to have the motivation towards settlement, especially on the part of bureaucrats who may feel politically that they can't settle. But that aside, you asked whether it was realistic to push for these contract changes. I suppose the answer is yes, because I have pushed for them, and I've advocated for them with my clients, and my clients have pushed for them, and they've been inserted into documents. You should go read. Honestly, the Ronda 1 license agreement in Mexico is publicly available. I'm not saying I've drafted it. I didn't draft every clause. These things have to be done through processes, et cetera, but the clauses are there, and the impetus is there. But you're right. Your degree of leverage will depend on the size of investment, to a degree, but it also depends on the amount of attention that's being paid to your contract clauses by the state.
Thank you. So I'll move on to Martin's. I saw that in your recent article on the ICSID review, you have argued for changing the principle of full reparation by introducing an exception to the crippling compensation, full crippling compensation. So you highlight cases where extremely high amounts of damages were awarded, such as Tatien, ConocoPhillips, and Can. I was wondering what practical implications for states does that lack of an exception for crippling compensation pose?
Right. Well, many thanks and kudos for such a careful read for recent publications. Right. So I think that is something that I think it speaks to my intuition that to the extent that there are hard questions raised by investment law, that they can often be addressed within the existing system by thoughtful reflection on the balance struck through the principles. And if we look at the broader rubric, I suppose, of the balance on the remedies part that was struck by the International Law Commission in the 2001 ILC articles on state responsibility, which have been broadly adopted with some intellectual question marks by the investor-state arbitration, I think there were some assumptions that were built in that would have worked, broadly speaking, in favor of the responsible actor and unfavorably to the injured actor, like skepticism about compound interest, and at the best, lukewarm attitude towards certain value calculation methods like discount cash flow. And as we know, both of those propositions have been fairly enthusiastically endorsed by arbitral practice, including indeed by many of the arbitral tribunals in which Judge Crawford, the final special rapporteur of ILC articles, himself presided over. So I think that the puzzle that I had when thinking about these cases, so, Kern and India, more than $1 billion, maybe a significant sum, but it is probably not something that would cripple the capacity of India to provide basic public goods. It may be more complicated if there is a 7 or 8 billion award against Pakistan or Venezuela. And I think, so my argument in the article, and I think ultimately, look, I'm very honest about it. I think it's ultimately in public international law, arguments are accepted if they are endorsed by states in their practice, in their pleading practice, treaty drafting practice, arbitral decisions. And of course, if there's no particular interest in states arguing those points, then possibly the issue identified is not as problematic. And I think that is really, as we all know, that there's a certain length of time from the time that arguments are invoked and we get the awards. I know that such arguments have been made in the interstate disputes and some regional human rights mechanisms. So I think the question is, I suppose, whether these are points that can be reasonably addressed already by existing mechanisms and arguments, sensitive application of valuation methods, principles on contribution and mitigation, or possibly, I think, one perfectly satisfactory counter-argument is to say that that is simply an accurate value of the injury caused. And in a very primitive analogy with tort and delict law, public international law does not really address the scope of the full reparation claim by reference to capacity of the claimant. Now, in domestic law, if somebody is incapable of paying, there would be certain limitations, but they would not really be expressed at the level of the content of the obligation. It would rather be something that would be expressed at the level of bankruptcy rules or enforcement of judgment rules or whatever have you, which we simply do not have at the level of public international law. And I think one other possible response, and I think that is what that Bible of public international law, Oppenheim's international law, said in the last edition, that if states simply cannot pay compensation, that is simply the starting point for negotiated settlement. And actually, in quite a few of these crippling compensation or possibly crippling compensation cases, that has been addressed to some extent in those terms. And indeed, it was reported some time ago that there may be an eye to negotiate settlement in Tetian. But I think that sort of perhaps brings to the bigger point that kind of if we have to abstract and look at the issue as a field and what public international law can give us as a balancing element. If I could just, before I pass as it were back to you, the very interesting discussion of the mediation and all those considerations, one thing that struck me, and I think that is a point that, not my point, so I think it's fair to say that is Mark Cantor's point, to say that to the extent that we are thinking about a $1 billion claim, we also have to take into account the fact that, say, spending 6 or 12 months on a possible but ultimately unsuccessful mediation will ultimately come back via interest, which may be quite a significant one for the state. So that could also be another factor to consider, that the length of time is not, as it were, priceless. The price will come at some point and it will hit the unsatisfactory part. It doesn't mean that this is not something I should be resorted to, but I wondered, kind of just throwing in that particular point that Mark usually says. Thank you, Lara.
Thank you. So I have another question for Shreyas, and I'll bundle it together afterwards with another question to Martin's. So Shreyas, my question is, how do you prepare for an investment mediationist council? How does it differ in your experience from preparations for the arbitration, or how is it similar? And my question to Martins, and feel free to decline to answer this question, this is in relation to a very recent ruling. So 4 days ago, the US Supreme Court ruled in the case of ZF Automotive against Luxshare that the US code does not permit discovery assistance from US courts for private, foreign, or international arbitrations. And I can quote you some sections if you like, but I noticed that one of the cases was pursuant to a BIT between Lithuania and Russia. So I was wondering what you think of this ruling, what kind of implications it might have for investment arbitration as a whole, because you talked about the role of investment arbitration as part of this wider network of public international law. And here it was, here the ruling was that the term tribunal is best understood as an adjudicative body that exercises governmental authority specifically. So whoever wants to start, please go ahead. Shreyas?
Okay, sure, I will. So thank you again for the question, and I will quickly respond to Martin's suggestion on, and also Mark Cantor in absentia, by the point on interest. Again, the presumption in that is that arbitration somewhat pauses, or that everyone stands and waits till what happens in the mediation. Once more, the way I perceive complex and sophisticated parties to behave is to be very cognizant of the economic costs of their actions and inactions, and to perhaps suggest either very strict timelines for a mediation to occur, or indeed sections where they could even have a parallel procedure. Of course, the mediator is not the arbitrator. You could even have the same counsel team or a separate mediation counsel team. And that is a segue to the question that Lara has posed, which is, and I can only answer this from my experience in preparing for complex commercial disputes, but I don't think the answer is any different when it comes to dealing with, if I were to prepare for a mediation, which I haven't yet had the opportunity to do in an investment treaty dispute. Right now, I'm just the evangelist for mediation in investment treaty disputes. First, put the numbers first. Ultimately, this is this dispute has a commercial beating heart to it. Understand where the parties are, understand where the current positions are, and try to identify where the interests of the parties lie. And it is with first an alignment of interests that then there can be in due course an alignment of positions. So the positions can be very divergent, but if parties are continually reminded of their own long-term interests, the investor to have his return or her return over a long period of time, host state to again be a credible destination for long-term investment, there is an alignment of long-term interests. And that would be the beginning point to bring the positions, which are currently very, very divergent, closer together. Second, where are the easy wins? Which part of this dispute, which appears to be miasmic, amoebic, all over the place, which aspects of this dispute are easy wins? And there are low-hanging fruit which you can identify where the parties' positions are as far apart as in other issues. Those can be tackled more easily. And last 2 points is we need to have a robust procedure which is agreed upon. Now, and it has to be by agreement. If the treaty doesn't contemplate it, if the contract also does not reference mediation, and slight correction and to what Gunjan said about cooling off periods being considered as mediation periods. Again, cooling off periods do not nominate a neutral third party to intervene and intercede. And it discounts the role of a properly trained catalyst in the role of a mediator. It's a professional intervention by a mediator, which the parties simply will not be able to do if left entirely on their own. And so that's the penultimate point, which is think carefully about the procedure that is appropriate for that particular instance and case. And finally, every procedure is as good as the people manning it. Give careful thought as to the emotional intelligence of the neutral. It may not, emotional intelligence may be totally irrelevant as counsel. One knows many nasty stories of brilliance being accompanied by lack of emotional awareness as counsel. It may not be entirely relevant for the purposes of arbitrator if one can maintain basic level of civility and courtesy. But it is intrinsic to the work of a mediator who will be able to read the mood of the room, read what is unstated between the lines, and draw the parties together. I'll stop there. Thank you.
Thank you. Martins?
Right. Thanks, Lara, again for another penetrating and sharp question. So, while Shreyas was speaking, I was reminding myself of Justice Barrett's opinion in the case that you mentioned. So, I think my understanding that where Reimagine reconfirmed was that the court concluded that neither commercial arbitration nor investor state tribunals would be able to rely on the procedural assistance of United States courts because they were not classified as either foreign or as international. So I think probably on the foreign point, it would be less surprising. I think that this is an interesting point, and even though I think that there's a temptation to say that domestic judicial bodies sometimes do not get points of public international law quite right, I wonder whether this might be one of those where a domestic court is speaking language that seems somewhat like public international law, but is really applying its own classification taxonomy for its own purposes. And I think that domestic courts sometimes struggle somewhat in trying to locate international bodies within their own domestic taxonomy and hierarchy. And I think that here, I have to say that the whole way how United States law approaches the issue in more general terms strikes me as slightly counterintuitive, of saying that, for example, an interstate dispute settlement mechanism would be an international tribunal for this purpose because it would be endowed of shared governmental powers. So the foreign courts would be single governmental powers, international courts shared. And that is not really how one thinks about international courts mostly. Surely the key point is that it is a third-party dispute settlement mechanism that operates precisely because it is not a body of either of the parties or a shared body. It is an independent mechanism, often in public international law, a separate subject of international law. So I think the very framing of the question strikes me as slightly peculiar one, and kind of the whole, the case law to which the court refers, the BG in Argentina. Some people, I think, might think that that was not a case that was much to write home about. US Supreme Court interpreting a UK Argentina BIT by reference to principles of American contract law is probably not the methodological approach that would get the distinction in my exams, but not to be, as it were, picking on the Supreme Court on that point. Equally, I think that the taxonomy of the Court of Justice of European Union and the reasons why for particular purposes tribunals count as courts or do not count as courts may also seem slightly counterintuitive. But again, that is the tension and challenge of public international law. By providing universally shared vocabulary, it fits everybody, but it doesn't fit anybody perfectly.
Laura, if I could make a comment on ZF Automotive.
Absolutely.
To understand that decision really, I think you need to look past, you have to understand the politics of what's happening at the Supreme Court level in relation to foreign disputes today. I've got an editorial coming out in the Times about this. 1782 was passed at a time when it was expected that other countries would follow suit and reciprocate with similar statutes of their own. And no other country has done so. So there's a feeling in the United States that we passed this very great statute that you all can use to the benefit of your courts, and none of you have followed. And the Supreme Court in itself is trying to kind of extricate the U.S. judiciary from settling disputes with what they view as a purely foreign nexus. So this is part of a trend. And then where the decision becomes head scratching is Justice Barrett and about 3 or 4 other conservative justices are also trying to push a hypertextualist, a textualist approach to the interpretation of litigation of statutes and the Constitution that relies heavily on the meaning in dictionary definitions that were available at the time of the Legislative Act, which has a host of problems as an interpretive model. So you have on the one, it's a 9-0 decision, right? And so the Supreme Court didn't rule 9-0 that we are not going to hand over evidence to commercial arbitrations and some forms of international investor-state arbitration. Exit arbitrations are not yet covered. Some forms of investor-state arbitration because they didn't have a good policy determination in mind. The deliberations at the court level must have been, why are we spending so much time and effort on an arbitration tribunal when the arbitral tribunal will determine the production anyway? I think that it's clear. And then Barrett's reasoning has to be understood as she's a new justice. She's going to be given some important decisions very early on, so she generates, so the Chief Justice is giving her important decisions early on, so she generates a track record. And then she has an approach to statutory and constitutional interpretation that would require them to look at the firm's foreign and international and come up with some reason that a foreign tribunal doesn't include a commercial arbitration investor state, or an international one doesn't. I think the international tribunal gets really wrapped up and doesn't make, and is very head scratching. I think in commercial arbitration, the arguments go either way. But that decision is a political decision in a lot of ways, and it's driven by the court's politics and what the court is trying to do with respect to American jurisprudence, not with respect to international jurisprudence. The court has basically decided we're going to give less and less to the international community until they start giving more to us.
Thank you. Thanks. I look forward to reading your piece in the news. In order to close, I'll hand over to Ankit now. Let me just be really pedantic about something in the introduction, which Ankit unfortunately got wrong. I am not acting against Russia in any way. I'm just providing advice to Ukraine. So Ankit, over to you.
Well, I'll just pick up from where Mr. Sharma left. And also, this has come up in quite a number of instances in this discussion as well, even when Professor Martins was speaking, is that this populist trend of leaders who have elected justices, especially in the system of the United States, wherein these conservative leaders are coming up, conservative judges are coming up with judgments which sort of backtrack on this international agreement, in some sense reflects on this system of foreign relations law and how internal laws are sort of predicated to counter international agreements as well. So I'm just very interested to know how everyone on this panel thinks about this reaction to these international agreements, but also how these populist trends can perhaps in some instances work in favor of the nationalist interests, which are so integral to the vocabulary of a populist leader. And I'll sort of weave this in with the question in the chat box as well, which says essentially asking about environmental concerns which may take priority over, let's say, economic interests, although examples for that might be far and few. But I'd be just very interested to know how this nationalist trend of conservative justices is influencing international law in domestic courts and how they're essentially reacting to these international covenants. And we'll close after this. So very briefly, everyone, please. Thank you. We can have Professor Martins first, then we'll have Mr. Gunjan, then we'll close with Mr. Shreyas.
Right. Well, thank you, Ankit. A fascinating and a very, very multifaceted question to which I will give a slightly possibly cop-out weaselly answer. I think as a general proposition, I find that even though we are all intimately familiar with the domestic jurisprudence on such issues within a particular jurisdiction or several jurisdictions, I think if we zoom out and look at the influence of particular domestic courts on the international legal process more generally, it is likely to be negligible. Because it is still, even for influential and well considered and regarded courts, it is 1 out of 192 states, and it is usually very unlikely that the point is raised, argued, and decided in a way that can easily be repackaged into the international legal process. So I think that would be, I think that my former colleague Roger O'Keefe had a great article in the Leiden Journal of International Law why domestic courts are almost entirely lacking in influence on certain issues of international law, and I'm broadly associating myself with that. Kind of, it may be fascinating within one block, but if we look at 192 blocks side by side, I don't think it really works that way. And the final, I think, the Mr. Tulsian's point that was raised regarding other fields and the interaction. And I mean, again, I think it's helpful to appreciate that this is not something that is investment law peculiar. And I appreciate that we are speaking in, as it were, the virtual world of India. And of course, many public international law cases involving India have raised precisely these sort of issues. In the Jadhav case, India tried to read the International Covenant on Civil and Political Rights into the Vienna Convention on Coastal Relations, unsuccessfully. In the Kishanganga case, the issue of environmental law was also considered in the background and didn't end up having much effect. So this, I think, is a very common tension, not peculiar to investment law, between a particular discipline with a limited jurisdictional scope and other concerns floating around there. I have to say that as a general proposition, I feel that bringing different vocabularies, different institutional assumptions in is, other things being equal, a worse choice than having, as it were, an internally developed and consistent vocabulary. So even though cases like Ecuador and Colombia got probably some things quite wrong, I think if we are trying to merge the WTO investment law institutions and vocabulary, it is unlikely that things would be going smoothly. So I think I would probably be inspired to take values and policies, but translate it into the native language of international investment law, and not be concerned if it's puzzling and hard. It should be puzzling and hard. International law is puzzling and hard on this point.
And the lawyers have to, the bread and butter of lawyers is hard and tough. Let's move to the lawyers now. We'll go to England first and we'll close with India.
Thank you, Ankit. It's a very interesting question on how I was talking earlier about political swings and how the swing towards what people pejoratively call populism, but there's also more national interest focused conservatism is another way to put it. Has affected, and it does affect international law, maybe not through judicial reasoning. So I was representing a private company in discussions with the US trade representative at the ambassadorial level during the renegotiation of NAFTA into what became the USMCA. And before the director was public, I was having a discussion with the ambassador on, I was seen as kind of a block on the passage, because not fully a block, but I was advising the client, this is bad for you. And the certain classes of disputes in the USMCA, dispute resolution, only provide for remedy in the case of direct expropriation and not an indirect expropriation, right? So direct expropriation is formal taking and transfer of title. Indirect expropriation is where you accomplish the same end, whether intentionally or not, without a formal taking of transfer title. And for 70, 80 years, the US policy, the policy of the State Department, articulated by Republican Democratic administrations, has always been indirect expropriation and direct expropriations are international law equivalents. You can't do through the back door what you can't do through the front door. And so I asked the ambassador, I said, look, are you changing 70 years of American policy today and signaling to the entire world that direct expropriations and indirect expropriations are different? And he didn't have an answer. I mean, to summarize his answer, it was like, we have to pass this, right? We have a populist president or a conservative president who wants to pass this treaty. This is the only way we're getting past this treaty because NGOs don't like indirect expropriation. He didn't say that, but this is a sui generis thing. But it's not sui generis, because then when I talk to other states that I train or I review their framework model treaties, and there's been 6 or 7 in the last 2 years, then some of them are putting in this distinction and saying it's in the USMCA, and I have to tell them, look, that was a political uniqueness of that swing. And if you tell an investor, I'll compensate you for direct expropriation, but not for an indirect one, but you're telling an investor, I'll figure out how to get your assets without doing it formally. So I do think that's having a real impact on international law. I think, look at Brexit. Brexit has a massive impact on a whole fields of international law, including the Northern Ireland Protocol will one day, possibly. So this is having an impact on international law, but not necessarily through judicial reason. I had one last comment on the topic of crippling compensation, and it's just a comment, and I'm not disagreeing with Professor Paparinskis, but I face in DRC Uganda, where we brought claims on behalf of the DRC against Uganda. The Ugandans talked about crippling compensation. You know, they committed awful atrocities and said if you gave the full amount that might be due, we could never pay. And now every state says that. They're always, 99% of the time, they're exaggerating, right? Even Pakistan, I think $4.5 billion award is payable by the Pakistan government. But, crippling compensation, you're not paying. But the point of public international law is not only to compensate loss. We don't award compensation and reparations solely to make whole the person who is harmed. We also do it to give an ex-ante incentive for the state not to engage in unlawful behavior. And so if you let crippling if you merely accept on their face a claim of crippling compensation, you're facing a situation where Uganda winning on crippling compensation means ex-ante, states don't have a disincentive not to, as Uganda did, massacre children and women and engage in horrific war crimes and loot resources and take timber and take diamonds. The real point is, if you're worried about crippling compensation, you should do it before you massacre women and children, not after. And that applies in a different degree to international investment. So that's just my comments. I'm sorry for taking a little more time than I think anticipated. Thank you so much, Ankit. Thank you, Professor Francis and Shreyas and Lara for the time.
We'll still hear the Indian perspective, and then we'll close. But I think what you're essentially saying is, at least these populist leaders, is when you give the American example, if it was a French, he would have essentially said, "L'État c'est moi." I mean, the state is me, and I decide. And at least with these populist leaders, that remains a trend. And you see the reverberations being felt even today. I'll invite our final comments, sir, and after this we close, please.
I will not merely parochially, but hopefully topically, end with a reference to my hometown, Bangalore, and bring to light the Bangalore principles on judicial conduct. Now, though it was primarily discussed in the context of human rights, what should be the approach of a domestic court when faced with an international norm, let us say, that is not fully captured into municipal law? To what extent will the international norm that the state has acceded to be read into provisions of domestic law? Is one aspect. And the second, more widely, and I'm now quoting from a text that is available on the UN website, which I think, Ankit, is more pertinent to your question, which is judges have to be reminded of principles of judicial conduct. And it is the lawyer's job to do so. So I do not think lawyers can be exempt when we're talking about reining in judges who wish to ignore some of these principles. Very quickly, in 2002, this draft code was adopted by the Judicial Group on Strengthening Judicial Integrity with the Roundtable of Chief Justices held at the Peace Palace in The Hague, after deliberations, of course, in the eponymous town that the discussions began. The first was independence, impartiality, integrity, propriety. You have each one of these expounded in detail: equality, competence and diligence. And then you have an implementation code that is captured. So this is a pithy document of about 8 or 11 pages. And I would invite your attention to this. And Ankit, I wouldn't worry about, personally speaking, good times and bad times. It is these principles which, frankly, are not just found in contemporary textbooks. If I may maybe slightly abuse the last word that I have to take us well beyond the modern world to the hadiths around the Quran Sharif or other even religious texts, which exhort how should a person be independent. How should, in an earthy way, a judge who's had a fight with their spouse that morning refrain from deciding the case of another? How we should be conscious as to whether there is a lack of, we are overtaken by anger, and then to hold back from judgment at that time. So I think the sources of learning are many. At a more prosaic level, and in the commercial side, some of these institutions have come up with notes for arbitrators. But I think the world still awaits a more full and comprehensive compendium of what does it take to retain a sense of propriety and judicial independence, infusing both pre-modern and modern sources.
And I think on that happy note, on that positive note, we can close. And for that, let me just thank all our speakers for taking out time to do this. This was truly a global talk. We're so grateful to everyone for doing this. We're also thankful to our participants for joining us. With this, we're actually closing this series, and I'm also formally relinquishing my presidency of the society. I do hope to continue with the society as well when I start my master's at SOAS as a Felix Scholar. But let me just thank Professor Martins, who's actually been a part of this initiative and continues to be a part of this initiative. I also welcome Shreyas and Gunjan to join this family, which is growing in strength to strength. Thank you, everyone. And perhaps most of all, Lara, for doing this, Lara, for expressing your interest, and also for moderating this quite expertly. You did it perhaps better than I could have. And well, you do generally deserve a clap. And thank you, everyone, for doing this. And good evening. Thank you.
Thank you. Bye.
Thank you. Thank you.
Thank you.
Bye.